under which section of the IPC a person, irrespective of his nationality, can be held guilty and is liable to punishment for any offences within India. Section 2 of IPC, Section 13 of BNS. The answer is this thing. Let us see what is Section 13 is saying in BNS. The question is under which section of the IPC a person means Indian citizen as well as non-Indian citizen, Indian citizen and foreigner, irrespective of the nationality, can be held guilty and is liable punishment for any offences within India. Section 13 is clearly telling every person shall be liable to punishment under this Sanhita and not otherwise for every act or commission contrary to the provisions thereof of which he shall be guilty within India. Every person, here is citizen as well as non-citizen. Whenever every person has been mentioned in section 1 subsections, you have to understand it is citizen as well as non-citizen. Otherwise, it has been clearly mentioned citizen of India wherever it is applicable. In section 1.5, we see the provision of the Sanhita shall also apply to any offences committed by any citizen of India in any place without and beyond India. In foreign country, any citizen will do any offence, he can be brought back to India and can be tried. Next, it is important. In section 1.3, we have seen every person. In section 1.5, clause B also, this any person word is coming. Any person on any ship or aircraft registered in India, wherever it may be, if any offence will be committed on any ship or aircraft. But a condition the rider is that ship or aircraft must be registered in India. Then if any person, that means Indian citizen or otherwise a foreigner, commits an offence, then he can be brought to India and tried. Here the answer is section 1.3 of BNS. Under which of the following a corporation is indictable? Vicarious liability, personal liability for a breach of statutory duty, personal liability on the basis of attributing to the corporation the conduct and state of mind of an individual, all of them. The answer is all of them. Yes, corporation is indictable if the liability is vicarious liability. If the offence is committed by the corporation, the person behind the corporation, the liability may be cast upon that particular person who is in control of that corporation. That is called vicarious liability. Personal liability for a breach of statutory duty. The statute has put a certain duty on the personal, on the corporation. The person who is responsible for that corporation, it is his personal liability. The person who is running that corporation has got the personal liability for breach of any statutory duty. Next, personal liability on the basis of attributing the corporation the conduct and state of mind of an individual. Actually, the corporation does not have its own mind. It is an inanimate body. It doesn't have life. But it can be run by the people behind it. Just like a managing director or board of directors or some other very important person has been put in such a responsible job to run that organization. Then that personal liability on the basis of attributing to the corporation the conduct and state of mind of an individual. If that offence has been committed and that thought guilty mind has come from any one of the persons of the corporation, naturally it will come from one of the persons of the corporation. maybe managing director or board of directors, or very few important officials, then all of them will be responsible. The answer is D. X participated in a child marriage of Y in another country. Child marriage is an offense. X and Y participated in another country. It is not in India. Both X and Y are still Indian citizens at the time of marriage took place. Whenever Indian citizens commit an offense outside India, their offense is punishable. That we have already understood it. It is called extraterritorial jurisdiction. Y is liable for punishment under Section 3. Y is not liable as the marriage took place on the foreign soil. Both X and Y are liable for punishment under Section 3. That is true because they are Indian citizens and the offense has been committed, which offense has been treated as an offense under BNS. That's why answer is C. Extradition is to surrender of one state to another of a person desired to be dealt with crimes of which he has been accused or convicted and which are justifiable in the courts of the other countries. B. A political act done in pursuance of a treaty or an arrangement ad hoc. C. It can be sought on either in terms of treaty or on reciprocal arrangement. All of them. Now we see what is extradition. Extradition means if any person commits an offense on Indian soil and he goes back in a foreign country, then he has to be brought back to India and tried here. That is one situation. Second situation is if any Indian commits an offense on the foreign soil, then it is punishable under BNS. He has to be brought back to India from that particular country where he is at that particular point of time, has to be brought back to India to put him under trial. That is one situation. The third situation is any foreigner, if commits an offense on Indian soil or in any ship or aircraft, then, and that person was living in a foreign country, he also has to be brought back to India because our BNS gives the scope to try that person in India. In all these three situations, fourth situation is also there. If a person, whether Indian citizen or non-Indian citizen, sitting in a foreign country, sitting in a foreign soil, tampers with the internet, then internet that is situated in India, then he is committing an offense under BNS. He has to be brought back to India. In such situations, how can we bring him back from that foreign soil? There are three methods. We have got Extradition Act. Under that act, there are certain provisions. If we have got any bilateral agreement with that country in which that accused is living, under the provisions of that bilateral agreement, we can bring him back to India. There is a second situation. So many countries come together and make an international treaty. Under that treaty, they agree if any accused will be found in their country, they are ready to export him to the country where the offense has been committed. Under that treaty provisions also, he can be brought back to India. Next, third condition is there. There is no treaty, there is no bilateral agreement. Even then, if a person is residing to a particular country, our government can make a ad hoc arrangement. You see, my accused is living in our country and he has to be brought back to my country to face the charges. That's why please bring him, please allow us to bring him back to our country. That is the situation. That is ad hoc appointment, which has been mentioned in B. In all these three conditions, which I explained, the answer is D. However, which of the following admiralty jurisdiction extends? Admiralty jurisdiction means the offences committed on ships. Section 1(5). The provision of this Sanhita shall also apply to any offences committed by any person on any ship or aircraft registered in India, wherever it may be. If on any ship or aircraft registered in India, any Indian or foreigner commits an offence, suppose the aircraft is flying in the airspace of Britain at that particular point of time, and an American committed a murder to a British citizen, but that aircraft is registered in India, then that person can be brought. The murderer can be brought to face the charges. He can be brought back to India to face the charges under this section 1(5) subsection B. The offences those will be committed on the ships or aircraft, they are called admiralty offences. Under the jurisdiction under which they will be brought back to India to face the trial, that is called admiralty jurisdiction. It relates to the ships. Offences committed on Indian ships on the seas. Yes, it is correct. Offences committed on foreign ships in Indian territorial waters. What is this thing? B. Offences committed on foreign ships in Indian territorial waters. I have already told that Indian territory extends up to 12 nautical miles from Indian seashore. If any offence is committed on a foreign vessel, on a foreign ship, but that foreign ship is within 12 kilometers of Indian coast, then that we treat it, that offence has been committed in India. Then that accused can be brought back to India and he can be tried. Such incident had happened in Kochi coastal area. A foreign ship, that Italy foreign ship, two sailors in that foreign ship fired two boatsmen of Indians in our Indian territorial waters. That is within 12 kilometers of Indian coast. Then they have been brought and tried in Kochi. And later on, their case came before the Honorable Supreme Court also. That is one of the landmark cases. We will read about that particular case at a later part of time. Which of the following is true about a special law? Laws are three types. General laws. Second category is special laws. Third category is local laws. General laws are BNS, IPC, CRPC, like that. There are special laws. These special laws relates to particular subject. For example, what are those particular subjects? Hindu Marriage Act. Hindu Marriage Act relates to Hindu marriages. That's why that is a particular subject. Similarly, Excise Duty Act, ED Act, that is a special act. Third one is NDPS Act, Narcotics, Drugs and Psychotropic Substances Act. Like that, Dissolution of Muslim Marriage Act. These are the examples of special laws. These relate to a particular subject. and on that particular subject only these laws will deal. Here the answer is which of the following is true about special law? It relates to a particular subject. It applies only to a particular part of the country. It is wrong. If any law applies only to a particular part of the country, that is called local law. What is the example of local law? Delhi Police Act, UP Educational Act. UP Educational Act is applicable only to UP. Delhi Police Act is applicable to Delhi, only territorial area of Delhi. These are called local acts. Excise, Opium and Cattle Trespass Act. These are subject laws. Excise relates to excise, opium relates to narcotics, and Cattle Trespass Act relates to only cattle. That's why the answer here is A and C, both A and C. These are special laws. It relates to particular subject and examples are there. And what is the local law? I told you. What is general law? I also explained you. Which of the following is false of section 34 of Indian Penal Code? Section 34, that's equivalent term is section 3, subsection 5 of BNS. You remember this thing. It is also explained several times. It is only a rule of evidence. What we have to find it? False. Section 34 is rule of evidence. It is right. It does not create a distinct offense. It is also right. It lays down principle of liability. Yes, it is also right. It is a penal provision. No, it is wrong. Actually, section 34 or BNS section 3 subsection 5, it does not provide any sentence or fine. Violation of section 34, if you have to prove that common intention is there, section 34 relates to common intention. It is not providing any offense. It is only a rule of evidence. It has to be combined with any other offense, just like murder plus common intention. Section 302 plus section 34. Similarly, section 299 plus 34. Like that. It will be section 34 will be combined with some other offense. Which of the following does not attract section 34 of the IPC, section 35 of BNS? It is somewhat a difficult question. It does not attract. Section 34 does not attract. Remember this thing. We have to find it. The accused husband killed his wife and threw her body into the well to the knowledge of co-accused. That means co-accused has got the knowledge. As yet, co-accused took the false plea that on date and hour of the incident, the deceased was present in the house. Yes, it is a common intention is there. That's why it is not. Section 34 can be attracted here. The accused was involved in looting the victims in broad daylight on the main public road. Main accused indulged in looting, but co-accused was simply standing nearby. Even then, common intention is there. That's why, in the case of main accused as well as co-accused, both have got common intention. That's why both are liable. Next, driver and cleaner of a bus, when form a common intention to kill the deceased, and in pursuance of the plan to kill him and take away the sale proceedings of the grain sold by him. Here common intention is there. That's why section 34 will certainly attract. In all these three cases, section 34 will attract. What is D? All of them except the co-accused in B. That means here the answer is D. Here co-accused is also equally have got a common intention. That's why Even in the case of B also, this section 34 attracts, but all of them except here in the answer, except has been given. That's why the correct answer is D. In this option, except is there. You have to clearly understand the meaning of the except, and you have to read it along with does not attract. Then the correct answer is D. In all these three cases, section 34 will attract. Next, section 54. Which of the following is false of section 34 or otherwise section 35 of BNS and section 149 of the IPC, section 190 of BNS? We have to find out false of section 34 and section 149. Section 34 is common intention. Section 149 is common object. Section 35 is in BNS and section 190 is BNS, equivalent sections. Now we have already understood the difference between section 34 and section 149. Section 34 does not by itself create any specific offense. It is absolutely correct. Whereas section 149 does so, it is also correct because section 149 is itself a distinct offense. This difference you have to understand. Section 34 does not create any special offense, but section 149 is a distinct offense. Next, section 34 speaks of common intention. True. Section 149 contemplates common object. Absolutely true. Section 30, we are finding false. Section 34 requires at least 5 persons who must share the common intention. Section 34 common intention, it is true, but 5 persons, it is wrong. While section 149 requires at least 2 persons to share the common intention, here it is wrong. In the case of section 149, 5 or more persons are required. That means here the words are changed. If these 2 persons come here in the place of 5 persons and 5 persons come in the place of 2 persons, then statement D, the option D is also correct. But here what is there? Section 34 requires at least 5 persons, it is wrong. Section 35 requires at least 2 or more persons. Similarly, section 149 requires at least 5 or more persons. That's why the answer, we are finding false statement, that is, answer is D. We will see this section 190 and section 189 of BNS. In section 190, unlawful assembly has come. The word unlawful assembly has come. That's why we have to understand what is unlawful assembly. Unlawful assembly has been defined in section 189 of BNS. Section 189 is an assembly of 5 or more persons. This 5 very important. 5 or more persons is designated an unlawful assembly. Not all the 5 persons wherever they assemble, but they assemble if the common object of persons assembled there is, if they have got a common object and with prosecuting that common object, 5 or more persons assemble, then it is unlawful assembly. What is that common object? Various instances have been given in section 189, subsection 1. You please go through the act. You can find out. If to prosecute only those objects, if 5 or more persons assemble together, it is unlawful assembly. Now we will read what is section 190. Every member of unlawful assembly guilty of offense committed in prosecution of common object. If an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object. Every person who, at the time of committing of that offense, is a member of the same assembly, is guilty of that offense. It is very important, the last part. If you are just a member of that unlawful assembly, you are guilty. You are a criminal. You have not participated in any act. Your act is only to be in the assembly. That is more than enough to attract section 190. That assembly has prosecuted common object. That object has been described in section 189. If you are a member of that assembly, then section 190 attracts. You need not to do any overt act. Next question. The basic principle which runs through section 32 to 38 of IPC is that in certain circumstances, some part of the act is attributed to a person who may have performed only a fractional part of it. If an offense has been committed, it has got certain parts. Only if we have done a fraction of that act, then also in certain cases, in certain circumstances, it will be attributable that whole act has been done by you. Section 32 to section 38. These are called joint liability sections. These joint liability sections in a clear terms along with section 34 and section 149. I will explain it as a separate chapter. That's why I am not going in depth so far as this particular question is concerned. In certain circumstances, B, an entire act is attributed to a person who may have performed only a fractional part of it. If he has done only a fraction, even then the entire act will be attributed to that particular person. In certain circumstances, an entire act is attributed to a person who may have performed the whole of it. The entire act has been done by him, then the entire act has been attributed to him. Next, in certain circumstances, no act is attributed to a person who may have performed only a fractional part of it. Okay? D. B is the correct answer. In certain circumstances, an entire act is attributed to a person who may have performed only fractional part of it. It has not been described between section 32 to 38. If you have done only a fractional part of it, you will be responsible only that fractional part of it. Even though you have got a common intention, that entire act will not be attributed on you. All about intention is true except one exception we are saying. It is a state of mind, yes. It is an objective element, wrong. It is a subjective element. Intention is subjective thing. It gets birth in the brain. It originates in the brain. It will be seen only by your own perception. That's why it is only a subjective thing, intention. Rarely susceptible to proof. It is correct. Intention always cannot be perceived. It can be rarely seen. Always a matter of inference. Yes, it is also correct. Absolutely correct. It is always inference. From actus reus, we go to mens rea. It goes, it backtracks from act to mens rea. Because mens rea originates in the brain, we cannot perceive it objectively. That's why we will derivate it from the actions of the accused. The answer here is B, because intention is not an objective element, it is a subjective element. Next, the word illegal is applicable to everything. We have already seen it, we have in great detail understood it. Which is an offense, yes, or which is prohibited by law, or which furnishes ground for civil action. All of them. Yes, answer is correct. We have already seen it. Again, if you want to see, you see it. Illegal means everything which is an offense or which is prohibited by law or which furnishes ground for civil action. Okay. Which of the following is true of intent of defraud? A general intention to defraud. Defraud has been defined in section 29. It has been defined in a very simple terms. Section 29. Fraudulently means doing anything with the intention to defraud, but not otherwise. The intention must be there to defraud. That mens rea is attributable to fraudulency. Dishonesty, fraudulently, intentionally, knowledgeable, all these words related to mens rea, guilty mind. Here the question is, which of the following is true of intent of defraud? A general intention to defraud without the intention of causing wrongful gain to one person or wrongful loss to another. Yes, it is correct. Because a general intention to defraud, the definition is also saying the same thing with the intention to defraud. Second, to prove intention of defraud, it is not at all necessary that there should have been some person defrauded or who possibly might have been defrauded by this act. It is also correct. Who victim need not to be proved in the defraud cases. The word defraud is of double meaning. It is also correct. Defraud has got a double meaning. That's why the answer is D. Next 59. This is a very important question. We have to understand it. In different forms, this question will come. The word document, as per section 29 of IPC, includes any matter expressed or described upon by any substance. That means you have to read very thoroughly the definition of document, which is in section 29 of IPC and section 28 of BNS. We have to read it very thoroughly. Illustrations are also there. Any one of them may come in the examination as a subjective question or as MCQ. Now, first, before answering that question, we will read the definition of document. Section 28 document means any matter expressed or described upon any substance. Substance is irrelevant. Any substance by means of letters, figures, or marks, or by more than one of those means. Either it may be letters, figures, or marks. And includes, again it is inclusive definition. That means which are mentioned here, beyond that also there are things that can be brought within the definition of document. That's why includes word has been used here. And includes electronic and digital record. It may be electronic or digital record, it may be called document. Intended to be used. There may be intention to use it or which may be used. Even it has been used as evidence of that matter. It has to be used or it has been used as evidence of that matter. Even though as it is the word includes has been put here, if there is no intention of using it as an evidence, then also it can be called a document. That explanation comes later on. Explanation 1. There are two explanations. Explanation 1. It is immaterial by what means or upon what substance the letters, figures, or marks are formed, or whether the evidence is intended for or may be used in a court or not. That means it may be used in the court or not. That is irrelevant. Similarly, it is immaterial on what substance it has been written. It may have been written on a paper, on a green leaf, or on a book, or on a pack of cigarette, or on a trunk of a tree, or on a stone, on anything. It may, it may be letters, or it may be figures, or marks. Examples have been given. You see, these examples are very important because directly from these examples, MCQs will come. A. A writing expressing the terms of contract which may be used as evidence of the contract is a document. Contract is a document. A check upon a banker is a document. It is a document check. A power of attorney is a document. These are examples. These are not exhaustive one. Beyond that also there are several documents. A power of attorney is a document. A map or plan which is intended to be used or which may be used as evidence is a document. Again, evidence means generally we get the impression that which may be put in the court before a judge. It is not that. In the illustration, in the explanation itself, it may be used in a court or not. Not only in the court. If any authority is there before that, the document may be placed. That is called a document. A map or a plan. This is also called a document. A writing containing directions or instructions is a document. Flow chart and all these things are documents. Similarly, directions given by a person to another person, that is also a document. What is explanation 2? This explanation 2 is very important. Whatever is expressed by means of letters, figures, or marks, as explained by mercantile or other usage, shall be deemed to be expressed by such letters, figures, or marks within the meaning of this section, although the same may not be actually expressed. In the world of mercantile, they have got different figures, they have got different marks, they have got different ways of expressing things. Those things expressed, they may be taken in the way what that mercantile field is using. That usage is applicable only to that mercantile area. Once we see the illustration, we can understand what this explanation 2 is telling. A writes his name on the bank, A writes his name on the back of a bill of exchange payable to his order. The meaning of the endorsement, as explained by mercantile usage, is that the bill is to be paid to the holder. The endorsement is a document and shall be construed in the same manner as if the words to pay the holder and words to that effect had been written over the signature. For example, a bill of exchange. A is the owner of a bill of exchange. He gives that bill of exchange to B. While giving that bill of exchange, he puts his signature on the back side of that bill of exchange. He just simply puts his signature. He writes nothing. Once a bill of exchange is tendered in the bank, that bank has got the liability to make the payment to the holder. Here holder is B. He has taken that bill of exchange from A. The bank has got the responsibility to make the payment to B. Why? Because on the back of the bill of exchange, A has put his signature. The signature in the mercantile usage means to pay to the holder. Who will be bringing that bill of exchange? The bank has to pay. That is the meaning of the signature. Even though pay to the holder has not been written there itself, the bank has to read it. That is the meaning of this illustration. Now we will go to the question. Which of the following is there? The word document as per section 29 of IPC includes any matter expressed or described upon any substance by means of letters, figures, or marks only, by more than one of these means intended to be used or which may be used as evidence of that matter. Both A and B, none of them. Yes, both A and B is the correct answer. We have seen the definition. Which of the following can be called a document as per section 29 of IPC? Banker's check, power of attorney, map, all of them. These illustrations have been given here. Answer is D. Thank you very much.